The unpreventable employee misconduct defense is a well-established defense used by employers when facing OSHA citations for years. J.D. Abrams, a trenching contractor in Texas, they applied the unpreventable employee misconduct defense to an OSHA citation that they were facing. And we covered that case in July of 2023 here on our webinar and podcast, the OSHA 3030. J.D. Abrams, they lost their appeal before an administrative law judge and appealed that decision. It went to the U.S. Court of Appeals in the Fifth Circuit. What did the Fifth Circuit say about J.D. Abrams' application of the unpreventable employee misconduct defense, and why did it hold as it did? We're going to discuss that today on this episode of the OSHA 3030. I'm Manesh, Rath here at Keller and Heckman, and welcome to the OSHA 3030. Well, welcome to the OSHA 3030, everyone. I'm Manesh Rath here at Keller and Heckman in our Washington, D.C. office, and I'm joined today by my good friend and colleague, Taylor Johnson. Taylor, great to see you.
Thank you. Thanks for having me, as always.
Well, we have a good topic today, and I think we should get right into it. This is the unpreventable employee misconduct defense.
That's right. So first, what we'll do is just give a recap of the facts of J.D. Abrams versus occupational safety and health. This is a case that we covered on our July 2023 episode of the OSHA 3030. So we'll get into the facts, just a little bit of a primer. Then we'll get into OSHA's burden of proof, the elements of unpreventable supervisor misconduct, which is the big sort of issue that we'll be discussing today.
Yeah, and then we'll talk about what happened at the administrative law judge level. What did the ALJ or administrative law judge say? And then they appealed it to the U.S. Court of Appeals in the Fifth Circuit, the circuit court for Texas, and how they handled the appeal.
Yeah, that's right. And then what employers should do, as always, we'll leave you with some practical takeaway action items for you to take back to your workplace. And then we are recording live today, so we have an off-the-record section in which we'll tackle some questions from our audience live.
That's right. We're live here in the Keller and Heckman studio on May 22nd, 2024. And so because of that, we get to do an off-the-record. This is exclusive to the folks who joined the OSHA 3030 as a live webinar and not available. It's off the record, no recording, so it's not available when we republish this program as a podcast. It's also available on YouTube, and all of our past episodes for the past 13 odd years are available on our website, khlaw.com/OSHA 3030. So check those out. That would be the portion without the off the record. So why don't we get into the facts? J.D. Abrams, a trenching company, excavation company in Texas.
That's right. And in December of 2019, J.D. Abrams was engaged in a waterline installation project in Austin, Texas, which is sort of the scene and the timing in which this incident occurs.
So they were laying water pipelines down along, I believe, a side of a road, and this requires trenching and then laying the pipe in the trench. And I think what happened the day before was while they were conducting their excavation, they were installing trench boxes, those hardened steel trench boxes, and in doing so, as they were lowering the trench box in to shore up the trench, they damaged one of the water pipes and it burst, and water went all throughout and caused extensive flooding and damage to their project.
That's right. And so what happened was the area director for the region was actually driving by and noticed what appeared to be an employee working in an unprotected trench. And so this caused an investigation and eventually ended up in a citation. J.D. Abrams was cited for having an employee working in a trench over 5 feet deep that was not protected from cave-ins, and then 2, for a ladder that did not extend above the minimum required 3 feet for the landing surface.
When J.D. Abrams looked into it, they found out that their supervisor, Ramon Rivera, he said, well, he was the foreman, and he said, well, because the trench box the day before had burst a water pipe, I had instructed my crew to not install trench boxes because it was too close to a water pipe and the risk of damaging a water pipe again was just too great. So I omitted that step of trench boxing, and that's unfortunate for him and for J.D. Abrams. That's when the OSHA inspector happened to be driving by. We should say in one sentence, there's a doctrine in OSHA law called the plain view doctrine. And so if an OSHA inspector, compliance safety and health officer sees something in plain view, that gives them sufficient basis for following up, asking to enter the premise, and if given permission to enter the premise, to go ahead and continue a physical inspection.
That's exactly right. And it's a key fact, like you said, Manesh, that, the supervisor here, Mr. Rivera, he was not the one who went into the trench himself to do the work, without a trench box, but he was the one who directed the employees to do that. That ends up becoming, a critical fact here in this story.
So, so the compliance officer sees the violations, the two entering the staff entering the trench without protection,
Right.
and then the ladder not coming up over the edge with sufficient amount above the edge, 3 feet.
Yep.
The trench was deeper than 5 feet where they were not using trench boxes, and so he issued citations. And J.D. Abrams contested
That's right.
both the citation items.
Contested both citations. They allege that they did not have knowledge of the hazardous condition and that Mr. Rivera engaged in unpreventable employee misconduct.
So again, as I'd started us off with, the unpreventable employee misconduct defense is a well-established defense. It's been used by employers on many occasions, but there are certain requirements that an employer must meet to successfully raise this defense. Why don't we start with what are the standards elements what are the elements of assessing a violation that OSHA has to meet when alleging a violation of a standard? Well, there's 4 elements that they have to meet in every allegation of a standards violation. And the first is that a standard applies, that the scope of the standard fits the circumstance, the activity that's being described in the alleged violation.
Yeah, and the second is that the employer did not comply with the terms of the standard. So, the employer's actions did not meet the letter of the law in terms of what the standard required them to do.
Right. So that's the first 2. You have to have a standard that applies and that the employer failed to meet that standard. And then the third is that there was exposure by employees to an allegedly violative condition.
And then the last and the key sort of element here of OSHA's burden of proof in this particular story is that the employer had actual or constructive knowledge of the violation.
You say this is key in this particular case because they're alleging the unpreventable employee misconduct defense, and that is sort of the obverse of this element, this affirmative requirement on the part of OSHA to show that there was, in fact, actual or constructive knowledge of a allegedly violative condition.
That's exactly right.
So if the employer is asserting that there is an absence of this circumstance, this 4th element, the actual or constructive knowledge, they may do so in the form of an affirmative defense, the unpreventable employee misconduct defense. And that defense essentially says that the employer shouldn't be held liable, even if the first 3 elements are established: the applicability of a standard, a failure to meet the standard allegedly, there might be alleged employee exposure, but that final element of knowledge shouldn't be attributed to the employer, or that setting that 4th element aside, there's another circumstance where the employer may allege, we've done everything we could, we trained people how to do it right, but the employee in question violated our protocol or his training and did so quickly that we couldn't have caught him, we couldn't have stopped him or her. And that's another variant of the unpreventable employee misconduct defense. So now when the employer alleges this defense, they have, because it's an affirmative defense, the employer has 4 elements that they have to establish in order to successfully mount the unpreventable employee misconduct defense.
That's right. And the first is that, that the employer, they established work rules designed to prevent exactly this, that, exactly the violative condition from occurring, that they had established work rules in place for that.
Yeah, so the employer has to show that there is work rules and then that they adequately conveyed them to their employees. This is essentially employee training or employee education, where employees have, we can establish under this defense that not only was there a rule, but the employee knew the rule.
And then did the employer take steps to discover the violation of those rules? So basically, inspections, monitoring essentially.
Yeah, that monitoring element is critical. It's the critical 3rd element. And the 4th element is that indeed, if an employer, while monitoring, notices an infraction by one of their staff, that they took measures to stop future infractions, either through disciplinary action or reprimand or additional training on the spot, maybe.
Right.
And those are the 4 elements. So there has to be a rule. The employer has to have a rule. They have to have trained on the rule or provided education to the employee, taken steps to monitor for compliance with the rule, and then enforced any infractions that they observed. J.D. Abrams alleged in its raising of the unpreventable employee misconduct offense that it was these four elements were all in place. And when the administrative law judge visited this case, the question that J.D. Abrams and OSHA argued before the administrative judge really went to these last two measures. The question of, did J.D. Abrams sufficiently monitor on an ongoing basis for possible infractions or possible demonstrations that employees didn't understand their training? And did they take any enforcement actions or disciplinary actions or send employee or reprimand or send an employee for additional training or education? So those are the two of the four elements that really became the hotly contested ones.
Right. And so what makes this case unique is that it's not just, unpreventable employee misconduct, but there's the fact that Rivera here was a supervisor. And so there's this idea of supervisor knowledge and when can it be imputed to an employer. There's actually three factors the courts will look at here. The first is, was the employee acting in a supervisory role at the time of the accident?
So Taylor, this is a variant on unpreventable employee misconduct.
Right.
This is where J.D. Abrams says, yeah, but so I think what OSHA wanted to argue to the administrative law judge was that the knowledge element was already fixed because the supervisor himself, Rivera, was the one who ordered that the trench boxes not be used and then ordered employees into the trench.
That's right. And then J.D. Abrams basically says that that's not true. We didn't have knowledge because it was an unforeseeable action by our supervisor that can't be imputed to us. We can't be everywhere at once, essentially.
They're saying he knew not to do that, not
Right.
to order that the trench boxes be omitted
Yes.
or order employees in without trench boxes.
Right.
And yet somehow he made those instructions anyways.
Yes, exactly.
And that was the act of unpreventable employee misconduct, not when the employee entered the trench, but when Rivera had ordered it
Yep.
and supervised the project in that manner. And that's the essence of the sort of rogue supervisor defense or unpreventable supervisory employee misconduct defense. You can phrase it differently, but ultimately it is a question of what the supervisors now we're going to whether the supervisor had rules to follow, was educated, whether there was sufficient supervision of the supervisor, and whether infractions by supervisors were enforced.
Right. And then, was it foreseeable? I think becomes a real question here. Was it, you can really, draw that causal link between the employer's knowledge and the supervisor's actions. If the supervisor's actions were foreseeable, if they weren't, then that link kind of breaks. And so that becomes a real key.
Yeah, I think it comes as a key because in OSHA law, this fourth element that OSHA has to establish, which is knowledge, it really comes down to actual or constructive knowledge. And constructive knowledge is defined under OSHA law as that which an employer knew or reasonably could have known,
Right.
or reasonably should have known with the exercise of reasonable diligence. And so that's, I think, going to require courts to examine reasonable foreseeability as a part of that
Yeah, exactly.
analysis. Okay. So the administrative law judge heard both sides, and ultimately they came to the conclusion that when you're talking about supervisors' alleged misconduct, the employer's ability to foresee has to be analyzed within the context of the employer's ability to foresee supervisory misconduct, not the employee's misconduct. So the moment the employee entered the trench is not the unpreventability event that of course need to analyze. They need to analyze the supervisor's conduct, which in this case was the decision to omit the trench box and send employees into the trench. The administrative law judge said J.D. Abrams had failed to prove that this was unforeseeable. I think one of the things they looked at was that the condition was in place for at least 6 hours before the OSHA inspector drove by.
Right, exactly. So that sort of, hurts Abrams on the question of knowledge. And then it also comes right back around to bite them again on this question of unpreventable employee misconduct. The ALJ here says that Abrams failed to prove the last two elements of unpreventable employee misconduct. And yeah, exactly, Manesh. One of the theories there was that there was, no real documentation or support that they took steps to detect safety violations because for 6 hours, the employee is here working in this trench, and presumably someone would have came by at that point and been able to remedy the situation.
Yeah, I think another thing that troubled the administrative law judge was that there were two people who were above Mr. Rivera in the totem pole. One's name was Mr. Clementino and another was Mr. Matute. And both of them knew about the drain pipe bursting the day before,
right,
but hadn't come around to examine that damage or the operations the following day to see how they were accommodating for that event. And that seemed to the judge to be a failure on J.D. Abrams' part to show a reasonable degree of monitoring or supervision
Right.
of
Exactly.
the supervisor.
Yeah. And then no corroboration also of the fact that Abrams enforced their work rules. They say that they had one, but there was no real record of, discipline or, going around and correcting folks on the right way to use the trench. And so that also comes back to hurt them as well.
Taylor, that explains why the administrative law judge rejected J.D. Abrams' defense of unpreventable supervisory misconduct.
Right.
Why does this go straight to the Fifth Circuit? Maybe we should explain that to our friends in the OSHA 3030 community.
Right. Right now, the Occupational Safety and Health Review Commission only has one judge. And so that's why one commissioner, sorry.
Yep.
Yeah. And so that's why this case went directly to the Fifth Circuit because the Review Commission was unable to take up the case.
Which essentially lacks a quorum.
Exactly.
And that's an unfortunate circumstance. For a long time, Commissioner Lehow and Commissioner Atwood, both appointed from opposing parties as nominees, were able to work together really well. And I credit both of them. That's a terrific accomplishment on both of their parts. They both have a career at the commission that they can be very proud of because they found issues that they could both move through the docket and issue opinions on. And it wasn't always ones that they agreed on every element of, but they were able to look for the elements that they could agree on sufficiently to keep the docket moving.
Yep.
Considerably, given their challenge of only having 2 of 3 seats filled. And now when J.D. Abrams' appeal comes through, there was only 1. And so for that reason, you're saying it went straight to the U.S. Court of Appeals for the Fifth Circuit.
Yeah.
Fifth Circuit. So right there, I think this makes this case worthy of reporting the OSHA 3030 because I think it's very seldom that OSHA law matters go as high as the U.S. Court of Appeals. And when they do, they're almost always very interesting issues that they're adjudicated upon.
Yep.
This is one of them.
Yeah, certainly. And so the case does go to the Fifth Circuit. And so what Abrams essentially argues before the Fifth Circuit, it's a few things. First, that the supervisor, admitted they had this evidence, after the fact that he admitted to making a quote unquote big mistake that was contradictory to his training. So certainly helpful evidence for Abrams in this case.
Right. So it's an interesting piece of the original record that they pointed to, but I think one of the concerns that the Fifth Circuit grappled with is when they looked at, so the standard by which the Fifth Circuit reviews this case on is whether there's any clear error.
Mm-hmm.
And when they looked at the evidence in the record, they believed that OSHA had put on a case meeting its 4 elements that we discussed earlier, and that the problem for J.D. Abrams in asserting an affirmative defense was that they had sufficiently put on evidence on maybe 1 or 2 of the elements of unpreventable employee misconduct. Maybe they had a rule and maybe they had effectively communicated it. But the Fifth Circuit really was troubled that the evidence supplied in trying to advance the idea that there was sufficient monitoring going on or that there was sufficient enforcement going on really went as a sort of mixed set of facts to severally whether the employee who entered the trench was sufficiently monitored, and then whether the supervisor in his decision to send employees into the trench without a trench box was sufficiently supervised. They found poverty in the record of monitoring activity of the supervisor.
Right. Exactly.
And so that's really the evidence you need for monitoring.
Yeah. Yeah.
And they also found a poverty of evidence that there was enforcement of supervisor breaches of protocol. And again, that's the evidence that you need to supply when you're talking about supervisory misconduct or a rogue supervisor defense. It doesn't matter then that J.D. Abrams has sufficiently put in evidence that they had a sufficient safety program, or that the safety program did call for routine or regular monitoring. If indeed what they're alleging is that the supervisor had engaged in an act that was unsupervised and inappropriate and outside of his instructions.
Right. So those were Abrams' arguments. And then, OSHA obviously makes some counter arguments before the Fifth Circuit. The first that, essentially, like you were saying, Manesh, real gaps here in testimony regarding safety audits, and undermined by other evidence in the record, failure to visit the site when the pipe burst that day, like we talked about, and that, post-inspection discipline alone is really not enough to prove enforcement.
Right. And I think that they also pointed, the Fifth Circuit pointed to the lack of an evidentiary record at the LJ level showing routine monitoring documentation.
Yep.
Or audit documentation or records of enforcement. And I think that their discussion of the Angel Brothers case is important as well. I think interesting anyways. The Angel Brothers case really goes to this idea of unpreventable employee misconduct and whether or not a supervisor's unpreventable and supervisory misconduct should be applied to the unpreventable employment misconduct defense. I think is something that that the Fifth Circuit did a good job of covering when talking about the Angel Brothers case as well as the Yates exception.
Yeah, absolutely. And what ends up happening here is that the Fifth Circuit upholds the citations. Abrams loses again. They say they failed to meet the burden regarding the fourth element of unpreventable employee misconduct. Agrees with the ALJ. The Fifth Circuit does. The post-incident discipline isn't enough. And then, like you say, Manesh, reliance on the Angel Brothers case here and the Yates exception on foreseeability. I think is really one of the main reasons why J.D. Abrams ends up losing.
So let's talk about what that said. So
Yeah.
the Yates exception, what we're both referring to as the Yates exception, is basically that what the Fifth Circuit said was this idea of supervisory misconduct will not apply to the defense if the employer has failed to adequately supervise the supervisor, because then it's difficult for them to mount a sufficient case that this was unforeseeable. And as you say, this idea that this condition was going on for 6 hours, and also that they had no record that they did monitoring, audits, or discipline. One of the things I thought was interesting in their treatment of the Angel Brothers case was a very short statistical analysis. They said Angel Brothers is a very large company. They've handled thousands of projects, I think something like 6,000 projects. And Angel Brothers came to the judge saying, well, we don't have a documented record of disciplinary action because nobody's done anything wrong. But if we see somebody having done something wrong, we would have discipline. The absence of a disciplinary record doesn't mean that we're not disciplining. It may mean that we haven't seen any violations. The judge in that case said, well, the OSHA inspector came by 5 times and on 4 of those occasions found violations. It's improbable that in the OSHA inspector's experience, violations were witnessed 80% of the time. And out of 6,000 projects, Angel Brothers observed violations 0% of the time. They would have been within some range of each other that would have rendered that minimal range by which those statistics varied to be in the statistical mix. But when Angel Brothers came up with 0 instances of violations and OSHA came up with an 80% rate, the court said they don't have to find Angel Brothers' assertion credible. And I think that that's an important point for employers to consider when mounting a defense under the unpreventable employee misconduct defense.
Yep.
Well, there's a few things I think employers should consider, and we probably ought to cover what employers should do in our remaining time. I think the first thing that I'm going to go out of order, Taylor, if you don't mind.
Absolutely.
Because it really just ties off of our last point.
Yeah.
Is to engage in robust monitoring of employee activity, supervisor activity, and then to document it.
Yeah. I think that's exactly right. And so another key takeaway here is that a supervisor's unforeseen actions is only a defense when it's the supervisor who performs the violative condition. So you see in this case that, J.D. Abrams thinks that they have this in the bag, that they've got this Yates exception, that a supervisor's own actions, can only be imputed when it's foreseeable. This was unforeseeable is what they argue. But the court says, hang on a minute, that only works if it's the supervisor himself who does the action. The supervisor wasn't in the trench. He was ordering the employee to go in the trench. And so that's why they lost. And so I think it's a key takeaway.
Yeah, I think that's right. So the education element of the unpreventable employee misconduct defense is critical here. Whether it's a rogue supervisor or subordinate employee, there needs to be records of educational programming for employees. And I've always said in the OSHA 3030 when this subject has come up, that it's also important not just to have records that the employee was trained, but that there was a written record of how the employer measured the employee's comprehension of their educational material. Maybe the gold standard would be observing an employee doing it properly and making a recorded note that they're observed doing it properly following their training.
Right. Exactly. Another good takeaway here is to train field staff on how to interact with OSHA during an inspection and remember these 4 elements. In this case, we didn't have enough time to get into all of it, but there's an instance of the inspector in the field asking an employee questions to get at exposure. For instance, like, do you typically use the ladder when it's in this condition? And the employee, I think, in this instance, gave way too much information, was sort of engaging in this hypothetical back and forth with the inspector, ends up establishing exposure right then and there. And, that box is checked. So it's just something to keep in mind.
Yeah, training staff on how to handle an OSHA inspection is a really critical topic. We do a lot of training at the corporate level for our clients. And if you're in the construction industry, you might see us in a couple of months. We'll be presenting on that topic before the construction industry in Denver. And that's an important subject. I agree. That's a really important one for employers to take away from this case. So we talked about documenting instances of monitoring the walkthrough and what you notice. And we talked about documenting the educational programming for employees and testing their comprehension. I think that it's also fair to say that anytime there's a disciplinary activity or even a reprimand, that needs to be documented so that you have a record that you engaged in disciplinary activity or enforcement of your rules. There's a misnomer or a misconception, Taylor, by employers or supervisors that there's such thing as a verbal warning that wouldn't get a written record, and then there's a written warning, and maybe the written warning some supervisors believe is more severe, but every verbal warning should be memorialized in a note in the supervisor's record, because all forms of discipline, reprimand, re-education, or retraining need to have a record memorializing them in order to assert this defense.
Right, that's spot on. It's very possible that J.D. Abrams was enforcing its work rules, but it had no evidence of that.
Certainly supplied no evidence.
Exactly.
Right?
There you go. Exactly.
And then finally, I think that we, as you pointed out at the beginning, it's the act that violates the standard that is going to be tested by a judge as to whether there's unpreventable employee misconduct. So if you're alleging the rogue supervisor defense, you have to point to the act of the supervisor and show all of the 4 elements, a rule, training, enforcement, monitoring, as to that supervisor's act, not the employee's act. You can't mix and match. That's it. I think for what we think employers should do, Taylor, we're going to stick around for the off the record. We'll be back again on the next OSHA 3030 on June 26th at 1 p.m. Eastern time. And we look forward to seeing all of you then. We have sister programs. If your organization is responsible for complying with REACH or TSCA, stay tuned for the REACH 3030 on June 12th at 10 a.m. Eastern and the TSCA 3030 at 1 p.m. Eastern on June 12th. These sister programs have been going on for years. They are run by some incredible and knowledgeable attorneys here at Keller and Heckman who focus every day on solving problems for our corporate clients in the fields of REACH and TSCA. So check those out and pass the word on within your organizations to those in your organization responsible for compliance with REACH and TSCA. Well, that's it for today's OSHA 3030. I'd like to thank our staff here at Keller and Heckman and thank Taylor Johnson, but on behalf of all of us, Taylor Johnson, myself, Manesh, Rath, and all of us, we'd like to thank all of you in the OSHA 3030 community, not only for staying tuned for another episode, bringing us around to closing in on a full 13 years, but also for spreading the good word. When you get this email invitation, please continue to spread the good word to 3 more people that you haven't forwarded the invitation on to, so that they know about the OSHA 3030 and we can continue in the process of educating the OSHA 3030 community on how to make workplaces safer. I think that's what we're all committed to. Thank you all. We look forward to seeing you next month. And until then, stay safe.